students. Today we will discuss about the Kesavananda Bharathi case. This case is also called as Kesavananda Bharathi versus State of Kerala case. And initially this case started as an individual versus state, but later it converted into a constitutional question. So let us try to understand the basics of it. The Kesavananda Bharathi, the petitioner in this case, he is the head of the Ednir Mutt, which is in Kerala. So in Kerala, the government has been enacted Kerala Land Reforms Act. According to this act, maximum landholding size for the religious institutions and also to the big families is only 25 acres, which means that any religious institution which has more than 25 acres has to transfer their surplus land to the government. So the Kesavananda Bharathi is very keen about this reform because he is not interested to give the surplus land which is belongs to the Ednir Mutt to the government. So for that he clearly says that the fundamental rights granted for him under Article 26 under Article 31 is violated. So he moved his petition in the Supreme Court. But over a period of time, the same question has been converted as, can Parliament amend any part of the Constitution, including fundamental rights? So initially the petition started as a single individual versus a state government's act, where the single individual is asking that under Article 26, he and his institution, religious institution, has right to manage religious affairs. But over a period of time, the same thing is converted into a wider question, that is, can Parliament amend any part of the Constitution, including fundamental rights? If we can go back to the background of the case, by the time of 1969, 70, 71, the Indira Gandhi government is in the picture. By that time, the slogan of Indira Gandhi government is Garibi Hatao, which means that reduces the poverty. We know that India is a feudalistic society over a period of time in the British India. So the main principle of Indira Gandhi was she want to take the surplus land from the large family holdings and she want to distribute it to the poor people, which means that the tiller itself is able to get the fruits of the farming. So with that aspect, so because the Indira Gandhi is little inclined towards to the socialistic pattern of the society, so with this concept she encouraged land reforms acts in the state governments, because we know that the land is a state subject. So under her direction, several state governments came with the different reforms act. Before that itself, the Kerala has one land reform act, that is Kerala Land Reform Acts 1963. After Indira Gandhi government suggestions, they have been done some amendments in 1971 and also in 1972. According to this Land Reforms Act, the maximum amount of a land a person or family which hold was strictly limited. So which means that the Indira Gandhi government is clearly against to the feudal ownership patterns and also favorable to the redistribution of the land. So in this Reforms Act, even they not exempted religious institutions. Even religious institutions are also part of it. So with this aspect, the Kesavananda Bharathi primarily contested his case on the grounds of the violation of his fundamental rights under two articles. One is Article 21, that is right to manage religious affairs. The second one is Article 31, that is right to poverty. Because once upon a time, the right to poverty is also a fundamental right. Later it is converted into a legal right. So before we are diving into the topic, let us understand what is this Article 26 and what is this Article 21. The Article 26 of the Indian Constitution will give right to manage religious affairs. So we know that Kesavananda Bharathi is the head of the Ednir Mutt, which is a religious institution. So that religious institution has a lot of lands with them. So the Land Reforms Act, which is done by the Kerala, which is violated Mutt's autonomy and it is taking the Muttam's land. So he contested that the acquisition of the Muttam's land interfered with the freedom of the religion under Article 25, that is freedom of conscience and religion, and Article 26B and D, which gave right to manage religious affairs and property. So that is the first aspect. The second aspect where he contested is about right to property, that is Article 31. So he also challenged this land reform as it is attempted to acquire the Matam's property without any compensation. Because in the Article 31 clause number 2, there is a clear cause that property cannot be compulsorily acquired without compensation. Here what the government is doing, if there any institution having more than 25 acres of the land, it is taking the land without giving any compensation. So according to Article 31(2), it is against to the fundamental rights. So he believed that Article 26 and Article 31 are the basis for his case. Now if we can go back little, if we can understand the cases in 1967, there is a case called Golaknath versus State of Punjab case. In this case, the Supreme Court directed that the Parliament does not have right to amend the fundamental rights. So we need to understand this case very well, because we are going to link this case with the following topics. So this is the thing actually which is happening. So we already told that Indira Gandhi is favorable towards to the socialistic pattern of the society, and she is trying to do lot of amendments in the Indian constitution where it is giving enough right to the government of the day to take some of the decisions even though they are against to the fundamental rights, because her main principle was Garibi Hatavo, and she is more inclined towards to the directive principles of state policy rather than to the fundamental rights. So with this aspect actually, she introduced two amendments act. One is the 24th Constitutional Amendment Act. The next one is the 25th Constitutional Amendment Act. Principally, originally, the 24th Constitutional Amendment Act, the main reason was previously just now we discussed in Golaknath versus State of Punjab case, it is clearly said that the Parliament cannot amend fundamental rights. And we also know that by the time under Article 31, right to property is a fundamental right. So Indira Gandhi clearly knows that if she is not able to change the fundamental right, and according to the judgment of Golaknath, if she is not able to touch the property, she is not able to acquire the large holdings, and she is not able to distribute to the poor. So what she done was, through this constitutional amendment, she clearly says that, so as per this Constitutional Amendment Act, the Parliament has the power to amend any part of the Constitution, including fundamental rights, which is quite against to the Golaknath case judgment. In the Golaknath case, the Supreme Court said that Parliament cannot amend fundamental rights. So she introduced an amendment to the Constitution itself that the Parliament has the power. And also she says that once the Parliament is approved any bill, it is mandatory for the President to give assent to the constitutional amendments. Generally, we know that the bill introduced either in Lok Sabha or Rajya Sabha, then it will go to the second house. After that, it will go to the President for the assent. The President has a right to decide whether the bill, he has to sign the bill or he has to send back for the reconsideration, or he cannot take any kind of the decision, which is a pocket veto. So to avoid that much this delay, which means that once the bill is passed in houses, it will go to the president, right? So the president has right to hold the bill for certain period of time. So to avoid even that also, in that provision itself, she clearly maintained that it is obligatory for the president to give assent to the any constitutional amendments we are doing. Along with that one, there is one more Constitutional Amendment Act she enacted, that is 25th Constitutional Amendment Act. So the main reason to do this Constitutional Amendment Act is in R.C. Cooper versus Union of India case, the Supreme Court invalidated the bank nationalization. We just told that Indira Gandhi is towards the socialistic society. By the time banks are in the private people hands, these private people are giving loans only to the manufacturers and servicing sector. They are not giving loans to the farmers. So Indira Gandhi feels that without having loan, it is very difficult to the farmers to do certain activities. So banks needs to be controlled under the government of India. So she went for the bank nationalization in 1969. But in R.C. Cooper versus Union of India case, the Supreme Court invalidated the Bank Nationalization Act for violating Article 31. Because the Article 31 says about not only about the right to property and also other miscellaneous things. The main objective of this Constitutional Amendment Act was to reduce the judicial interference in laws promoting socio-economic justice. So, according to as per this Constitutional Amendment Act, they introduced one article, that is Article 31 Clause C was introduced. According to the Article 31C, any law which is giving effect to the DPSP, Directive Principles of the State Policy, they shall not be void even if it violates Article 14, 19, 31. We know that Article 14 to 35 comes under the fundamental rights. The directive principles of state policy, there are just directives to the state to achieve the economical well-being of every person and also other things. There the different directive principles are there. Now, if the Indira Gandhi want to achieve the principles of social justice, equality, redistribution of wealth, those things if she want to achieve, obviously she needs to undermine some of the fundamental rights and she need to give more importance to the DPSPs, Directive Principles of State Policy. So the Article 31C says that any law which is giving an effect to the DPSP under Article 39 shall not be void even if it violates some of the fundamental rights like Article 14, 19 or 31. So over a period of time, the Kesavananda Bharathi case eventually become historic battle about Parliament's power to amend the constitution, because the Kesavananda Bharathi is challenging Article 26 and Article 31. Based on Article 26 and 31, by the time Indira Gandhi government is doing some constitutional amendments where through the constitutional amendments it is taking the Parliament power and it is giving absolute powers to the Parliament to amend any part of the constitution. So the battle of the Kesavananda Bharathi case is drawing parallels to all these developments. So over a period of time, the Supreme Court also considered applied these parallels to the Kesavananda Bharathi case as well. Now we will discuss about the Supreme Court verdict. So in the history of India, that is the largest bench, which is largest Supreme Court bench which is established so far, where 13 judges are there. The judgments were distributed as 7:6, which means that 7 people are in favor to one side, 6 people are on the other side of the coin. So which means that generally there is a lot of debate is there, because these 6 judges also written different opinions about the judgments. Just because of one extra vote, the Supreme Court verdict has been passed. So we will see that how the Supreme Court has been responded to this question. The first question is whether the 24th constitutional amendment is upheld or not. What is 24th constitutional amendment? It is giving powers to amend any part of the constitution. So it is giving powers to the Parliament to amend any part of the constitution. The Supreme Court says that yes, it is constitutionally valid. The Parliament has an absolute right to part any part of the constitution, but it has certain limitations. So in this case, the Supreme Court clearly says that Parliament can amend any part of the constitution, but it cannot alter the basic structure of the constitution. So in the Kesavananda Bharathi case, the Supreme Court also addressed the validity of the 24th Constitutional Amendment Act. So it says that the Parliament has right to amend, but it not change the basic structure of the Constitution. Here is the point. Even though it is saying that the basic structure, it is not given the exhaustive list of the elements which are included in the basic structure. So the 24th Amendment is valid but subject to the basic structure doctrine. Now we will see the 25th constitutional amendment. So here also partly the amendments were upheld and some of the parts were struck down. Let us see what it is upheld. Let us see what it is struck down. So the 25th Amendment Act, it made 2 changes to the Article 31. One is Article 31C. And in the Article 31 clause number 2, instead of the word called compensation, they just used the called amount. So to skip the judicial scrutiny. So compensation means they have to give the exact to the market value. Amount means they can give any amount. It might be the market value or less than the market value also. So this provision actually, so the inclusion of clause 2 in Article 31, the court says that this constitution is valid. But the courts also says that Giving priority to the directive principles over fundamental rights are okay, but you cannot say that it cannot be challenged in the court. So, which means that if you are giving such importance to the directive principles of state policy to implement economic well being and other well beings to the citizens, sometimes you may have possibility to violate article 14, 19 or 31. It is absolutely fine, but the thing is you cannot say that those type of the things will not comes under judicial review. So it says that laws implementing article 39 b and c are protected, but it excluded the judicial review. So it struck down the part that excluding the judicial review is unconstitutional. So any person or any citizen can go to the court and they can challenge the government decision for violating certain kind of the fundamental rights to implement the directive principles of state policy. So article 24 is completely validated. Constitutional amendment of 24th is completely validated and it upheld fully, but the 25th constitutional amendments is partly upheld and partly struck down. Now if we can see what constitute the basic structure of the constitution, we have given some illustrative points here, but they are not exhaustive. You can refer some more, but basically these things are the primary components of the basic structure of the constitution. In that, supremacy of the constitution, rule of law, separation of powers, judicial review, federalism, secularism, parliamentary democracy, unity and integrity of the nation, free and fair elections, and fundamental rights. Now let us see what is the outcome in terms of the land reform law, because it is all started with respect to Kesavananda Bharathi versus state of Kerala, right? This is where it started. So because the Supreme Court already upheld the 24th Constitutional Amendment Act, which means that the Supreme Court is giving right to the governments to implement any kind of the law which is in favor to the DPSP, even if it violates some of the fundamental rights. So the Kerala Land Reforms Act, he is challenged under Article 31, right? That is right to property. Now this right to property is gone because the government is giving lot of importance to the DPSP, and it is okay to undermine Article 31, that is fundamental right of the Constitution. So in this case, actually the Kesavananda Bharathi was lost. He not won, but he won technically because it is giving restraint on the parliament capacity to enact any kind of the law which is against to the basic structure of the constitution. So technically on paper the Kesavananda Bharathi has lost its case, but this case is very very important in the Indian constitution and also in the Indian judiciary. If you can see the importance of the Kesavananda Bharathi case, it established the doctrine of basic structure. So it clearly says that the parliament cannot alter or destroy the basic structure of the constitution. The second important thing is it reconciled the parliament's amending power and judicial safeguards. So it says that parliament has an absolute right to amend any part of the constitution, but you cannot say that it not comes under judiciary perspective. So any person can come to the court and they may challenge the parliament's amendments, the constitutional amendments actually. So if you can observe, before Kesavananda Bharathi case, we already discussed about Golaknath versus state of Punjab. According to that, the parliament could not amend the fundamental rights. But after Kesavananda Bharathi case, it clearly says that parliament has a right to amend, but it is judicially imposed certain limitations in the name of the basic structure. Okay, so this case actually balanced the supremacy of the parliament and also the supremacy of the constitution. The third important thing is it checks the arbitrary government power. So on the judgment actually was delivered during Indira Gandhi's regime, which was pushing constitutional amendments to implement her socialistic and redistributive agenda. So this ruling acted as a constitutional safeguard against the misuse of the power and also authoritarianism. The fourth one is it preserved judicial review as part of the basic structure. So judicial review itself is a part of the basic structure and you cannot touch the basic structure. So judicial review should be there in every amendment you are doing tomorrow. So that is preserving of the judicial review is one more important thing. The other important thing is it also guided the future constitutional amendments, which means that this judgment is almost acts like a beacon light. Even the parliament is also very careful now to amend any part of the constitution, because parliament also knows that if it do any constitutional amendments now, it may be subjected to the judicial review in future. So it guided the future constitutional amendments as well. So finally, we can say that the Kesavananda Bharathi case is not just a chapter in our constitutional history; it is very much cornerstone, and almost it defines the entire. It defines the basic structure of the constitution, and the basic structure doctrine is almost like a constitutional Lakshman Rekha. The government should not cross it. If it tries to cross it, obviously the judiciary come into the picture, because the judiciary is an eternal guardian of the constitution, and the constitution is an eternal guardian of liberty, justice and the rule of law. So this is all about the Kesavananda Bharathi case, and try to understand, try to link the constitutional amendments to the Kesavananda Bharathi case so that you can understand in a more elaborated way. Thank you.